Can I welcome members then to the 57th meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that the examiner statute rules had been scheduled to attend today's meeting to discuss advice requested by the committee. However, due to unforeseen circumstances, this has been rescheduled to the 15th of January. So can I advise members that it is proposed that oral evidence session with Department of Justice officials on the Justice Bill will be recorded by Hansard, and can I seek your agreement to do this? Agreed? Can I remind members then that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises. Can I ask members whether there are any interest to declare at this stage?
Sure.
Go on ahead, Danny.
Yeah, just an immediate family member works for the probation board.
Thank you. Brian?
Just reading a couple of items of correspondence. I'm a member of the Committee for Finance.
Thank you. Brian, any more? No? Okay. Agenda item number 1 is apologies then. We have received no apologies. We have a full suite of members. We can also advise members that committee members Ciara Ferguson, Patsy McGlowan, Connie Egan and Danny Becker will be attending the meeting virtually. Agenda item number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday, the 27th of November 2025 are at pages 5 to 17 of the meeting pack. Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 27th of November? And if so, I'll sign the minutes. Everybody agreed? Okay. Thank you. Agenda item number 3 then is matters arising. 3.1, the Bar of Northern Ireland request for papers. Can I refer members to pages 19 to 21 of the meeting pack, which is a request from the Bar of Northern Ireland for copies of the papers provided by the Department informing the Committee of the plans to undertake 2 engagement processes on options for legal aid reform, which were considered at last week's meeting. A further request from the Bar for the written papers for the departmental evidence session held on the 20th November on the Enabling Access to Justice programme and the taxation reform was received yesterday and is included in the table pack at pages 3 to 5. So can I ask members if they are content to forward the papers for both legal aid reform items and enabling access to justice and taxation reform to the Bar of Northern Ireland as requested? And members agreed. 3.2, draft response to the Assembly and Executive Review Committee. Can I remind members that at the meeting on the 13th of November, members considered correspondence from the Assembly and Executive Review Committee in relation to a review it is conducting into the development of a formal process and guidance on the handling of Westminster statutory instruments, which include a role for the Assembly because they impinge on devolved matters. The AERC had asked all statutory committees for examples of any statutory instruments that they may have handled. Members agreed that the committee staff would prepare a response for consideration and agreement by the committee prior to issuing to the AERC. So can I inform members that a draft response is now available at pages 22 to 43 of the meeting pack? So can I seek members' agreement to issue the draft response to the AERC? Agreed. Can I ask members if there are any other matters arising from the minutes that they wish to raise at this point? If there are none, then we'll move on. Agenda item number 4 is Justice Bill, Department of Justice Oral Evidence. Can I refer members to pages 45 to 134 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Department of Justice officials as part of the committee's scrutiny of the Justice Bill? The witnesses providing evidence today are Dr. Veronica Holland, Deputy Director of Rehabilitation and Reducing Offending Division, and Jenny McAlarney, Policy Official, Reducing Offending Division. Can I advise members that Veronica and Jenny are in attendance today to speak to Part 2 of the bill on children's bail and custody and the planned amendment on restorative justice. Additional officials will be in attendance next week to speak to the other aspects of the bill and remaining amendments. Can I suggest that the committee commence with considering Part 2 of the bill and then focus on restorative justice separately once members have concluded their questions on children? So can I ask members as usual to indicate to the clerk if they wish to ask a question, and please keep questions as brief and focused as possible. This isn't the time for opinions, this is time for scrutiny and questions. So without further ado, can I welcome the officials to the meeting. Veronica and Jenny, you're very welcome to the committee, and can I invite you to make an opening statement?
Thank you, Chair. And that's very helpful to give us that demarcation between doing the youth justice provisions first and then turning to the restorative justice aspect. So more than happy to kind of set that out that way. And obviously we're happy to answer any questions from members in relation to both those aspects. So I'll first of all give a high-level overview of the youth justice provisions, the overarching aim of which is to enhance the Department's compliance with Articles 37B and C of the United Nations Convention on the Rights of the Child, and there's obviously a range of provisions in the bill that are dealing with issues associated with that. So as I say, I'll just give a quick overview in terms of what the provisions deal with, and then we can deal with any queries in relation to those. So clauses 4 to 8 of the bill amend existing legislation governing both police bail and court bail for children and address issues relating to the remand of children in custody. And those amendments are being made to ensure that custody for children is a measure of last resort. And in summary, they aim to achieve this through the following means. So they'll strengthen the existing presumption of bail for children through the introduction of a statutory right to bail. It will also introduce unconditional bail as standard, and associated with that there'll be a requirement that any conditions applied in relation to bail should be both proportionate and necessary. And there will also be the introduction of 2 tests that must be met before a child is remanded into custody. And the first of those is that the likelihood that the child will receive a custodial sentence in relation to the offence, that it's very likely that there will be a custodial sentence associated with that. And the second test is that even if that first test is met, that it's deemed necessary to remand the child in custody to prevent one or more of the following. So things such as failure to surrender to custody, another offence being committed, interference with witnesses, or causing a serious risk to public order. So as I say, really 2 strands in relation to that. First, that it's very likely that there would be a custodial sentence, and even if that test is met, there's then the consideration in terms of whether it's necessary to remand the child for those particular reasons. The provisions also introduce considerations which must be taken into account by either the police or courts before making decisions on bail, and these include the child's best interest, their age, maturity and understanding, as well as the nature and seriousness of the offences that they're being considered for and any previous offending history. So again, very much kind of look at the round in terms of the particular circumstances of the case and take into account any of those factors which would impact on the decision as to whether or not bail would be appropriate, remand would be appropriate in those particular cases. Clause 7 is then providing greater clarity on the options that are available to the police in dealing with a child who has breached or who is likely to breach their bail conditions. And depending on the seriousness of the breach, it can allow bail to continue for a record of that breach to be provided to the court at the next scheduled hearing. So again, I suppose very much a focus in trying to ensure that going into a custodial environment is a last resort, and that there's adequate provision made in relation to the provision of bail for those individuals. Members will also have heard from the evidence sessions that children have on occasion been held on remand rather than bailed due to a lack of suitable accommodation in the community. So clause 8 would prevent the police and courts from retaining a child in custody solely due to a lack of accommodation, where all other considerations for the granting of bail have been met. And unlike the remaining youth justice provisions, which will be commenced on royal assent, clause 8 will not be commenced until there's suitable alternative accommodation provision in the community. And we obviously continue to work with colleagues in health in relation to that matter, given that they would be the lead department in relation to the provision of that accommodation. Turning then to clauses 9 to 19, these amend the current custodial sentencing framework for children, and again it's in order to enhance the department's compliance with Article 37C of the United Nations Conventions on the Rights of the Child, and that concerns the separation of children from adults when they're in custody, so ensuring that there's a child-specific focus for the environment in which they're detained. And while there's been an administrative workaround in relation to that in place since 2012, which ensures that children are held in separate custodial environment, the new provisions will obviously place that in statute, ensuring that when a child is held in custody that they'll be detained in a juvenile justice centre and never in an adult prison, so they wouldn't be held in a young offenders centre. It's also our intention that the new provisions will meet a secondary policy aim, which is to reinforce the principle that all under 18-year-olds are children and they should be subject to child-specific sentencing and accommodation arrangements. So again, very much in line with the provisions of the UNCRC. And to this end, a new custodial order is being introduced through the bill, and that will replace the existing Juvenile Justice Centre order and also the order of detention in a young offenders centre. So that's commonly referred to as a YOC order. And that will become the new main sentencing option for young people under the age of 18. So the characteristics of that new youth custody and supervision order largely reflect the current provisions that are in the Juvenile Justice Centre order, in that there will be a two-part split between custody and the community. And in the majority of cases, the duration of that new order will be a minimum of 6 months through to a maximum of 2 years. And as with the Juvenile Justice Centre order, only one of the new orders can be in place at any one time. I suppose just to advise members as well on some of the key differences between the order that's currently in place. The new order will only apply to those aged 14 and above. For those aged 16 and over, the judiciary will be able to extend the length of the order by a further 2 years. And the purpose of that is very much to reflect the removal of 16 and 17-year-olds from the scope of the YOC orders, which can be applied currently for up to 4 years. So there'll be provision made in relation to 16 and 17-year-olds to make provision in relation to that, and I suppose continue with similar provisions for that age category. Another change or difference from the current provision is really in relation to the split between custody and community provision. There's greater flexibility given in terms of the new order in relation to that. So instead of there having to be a 50-50 split as it is for the current order, the judiciary can decide to allow for a longer period under supervision in the community. And the conditions that are associated with that is that the custody period can't be any less than 6 months, and it can't be any more than 50% of the order. Can't be less than 3 months or more than half the length of the order, apologies. And a breach of the supervision element of the new order can result in the young person being sent back to custody to serve the remainder of the order, as opposed to the current position where the maximum custody period is for 30 days. A few other things that we just want to highlight in relation to that is that where a child has committed a very serious offence which would necessitate a sentence beyond the duration of that new order, there are a range of other custodial sentencing options that would remain available to the judiciary. So it's not that there are any kind of limitations or restrictions in relation to the ability to deal with individuals where they are of a young age but a very serious offence has been committed. And obviously the provisions will continue to apply to all children over the age of criminal responsibility, whatever level that may be once the bill has gone through the assembly process. Finally then, just in relation to the youth justice provisions, further custody related issues are addressed in part 2 of the Justice Bill, and they have included the removal from the statute book of custody care orders which were intended for 10 to 13-year-olds. Those provisions have never been commenced since the legislation was introduced 23 years ago. Provisions requiring the court to take account of time spent by children on remand, both when considering extending the remand period and also when determining an appropriate custodial sentence period upon a finding of guilt. And then also provision is made in relation to transitional arrangements which provide clarity and ensure continuity of custody provision at the commencement of those provisions. I suppose just more generally, we've obviously followed the committee stage of the bill in relation to the youth justice provisions with interest, and I suppose we've been encouraged by and found it helpful to see the level of support that's been demonstrated across the board for the youth justice provisions by stakeholders. While some issues have been raised, we hope the department has addressed the majority of these to committee members' satisfaction through the previous written submissions that we've provided during this stage of the bill's progress. And we're obviously aware there are a small number of outstanding issues which have been sent through for the department to consider, and we're in the process of responding to those, and would hope to get something with the committee fairly soon. We understand that there's going to be a composite response that will deal with the range of provisions and queries across the bill more generally, and obviously the youth justice provisions will be an aspect of that. So I think it's hoped that that response would come back to the committee early in the new year. As you said, more than happy to answer any queries that committee members may have in relation to the provisions, or if there's anything else that you want some further clarification in relation to.
Okay, Veronica, thank you very much for that presentation. It was very, very helpful. I'll kick off, I suppose, and I will allude to the clauses of the bill. Clause 4, we're adding in new terminology around the juvenile's age, maturity and needs. And this is Article 39 of the Police and Criminal Evidence Northern Ireland Order 1989. Duties of a custody officer after charge in paragraph 2A omit the and at the end of that's just basically the add on another subsection, and then the subsection added is in the case of an arrested juvenile, the juvenile's age, maturity and needs will be taken into consideration. How do you envisage someone measuring that maturity, and how does that look like when it's in the face of a bill?
I suppose that's something, it will be for police officers to take account of the individual circumstances of that case. To our mind, that's something that they would be considering, I suppose, as part and parcel of their daily operations at the moment. The intention is also that there will be guidance associated with the provisions in the bill more generally, and we'll obviously continue to have discussions with police in relation to the operationalisation of those provisions and how they may best wish to consider this. But, I think generally speaking, we would be of the view that those are aspects that the police will already be taking account of as part of their work more generally. I suppose it's really reflecting that in statute.
Thank you.
Sorry,
go on ahead.
We just say we have had talks with the police, particularly in relation to that clause actually, and how they would assess maturity, and based on those discussions they're content that they would have the operational expertise without really detailed guidance in relation to that. I think they understand is something that they do probably as part of their normal processes generally, and obviously they'll be looking at the child, any information that comes in from the child's appropriate adult or parent as well, in terms of the child's maturity and street wiseness, if you know what I mean as well.
Yeah.
So.
Does mental age capacity come into it?
I don't think it would come into it for that particular. That would probably come under the needs, the wider sort of in terms of age, maturity and needs of the child. If they had any special, needs or learning difficulties, they would need to be taken account of. And the police would only obviously be aware of that if somebody makes them aware of that. I mean, we wouldn't expect them just to be able to determine that on their sort of brief interview with the child, but that would be for the appropriate adult or the child's parents then to make the.
But I suppose as part of their deliberations more generally, the police generally will be making an assessment in terms of kind of the capacity and ability to understand in relation to the young people that are coming into their care. Obviously there are also provisions such as the likes of registered intermediaries and that where individuals have perhaps a more limited understanding or learning difficulties or some other kind of aspect which may impact upon that. So there are, I suppose, aspects within the system already that would also assist with that type of thing.
We're creating a new on page 19 of the bill. We're creating a new 48ZA bail after arrest juveniles, and within that subsection 2 you've got a list. The nature and seriousness of the offence, the character, associations and community ties of the juvenile. Goes through a whole lot, but that's similar wording to the existing Article 39 in the existing legislation. So we've basically just replicated from the old bill into the new bill. Is it just tidying up the wording, or is it adding something to it?
Well, is adding something, I suppose, because this relates then to conditions of bail in this section. So it's whenever you're considering conditions of bail, not just the decision to release a child on bail, you should also be considering all these other things as well. And this replicates then what is in clause 6 around court bail. So the police and the courts will be making the same decisions based, on the same considerations.
Right,
so we need to make sure there's parity between court and police as much as possible.
Staying on page 19, and it's clause 5, police bail after arrest. We add in new terminology around, and he keeps talking about, the belt keeps talking about he, but he does not cause a serious threat to public order. Preventing that person's release from causing a serious threat to public order. On page 21, which is clause 6, then a new condition 10F and new clause 10G. It talks about the child's release causing a serious threat to public order. So I suppose we want to establish everywhere you add the serious threat to public order, are you talking about the child causing a threat to public order, or are you talking about the community causing a serious threat to public order?
Well, it's not prescriptive in the legislation, so it can apply to either. The reason we've included this is because there was a big report on bail carried out by the Law Commission in 2012, and in that report the Law Commission recognised this as a fourth ground for refusing bail. And it was also endorsed as well by the European Court of Human Rights, also recognised it as a fourth ground for potential for refusing bail or for applying bail conditions. So that's why we've replicated it, we've taken this chance then to include it in this legislation. But it can apply to either, so it could apply to a case whereby the nature of the offence the child has committed is so, I suppose, serious that there could be riots. I suppose we've seen that, obviously in the past while, that their release could cause a riot. Or it could be that the child himself could be involved in serious offending of a public or disorder nature. So it can equally apply to both. But just to say that it should only be applied, obviously, for court bail if the first test for remand is met. So it has to be a serious offence. It would, result in the child having a custodial sentence anyway.
Yes.
So it couldn't just be applied for that basis on its own.
Yep. Staying on clause 6 and the new clause 10A, record of decisions concerning bail, 10A. 2C, if the child requests it, cause a copy of the record to be given to the child. How will the child know his rights around a decision concerning bail?
Yeah, well, that's a good point. I mean, obviously in our guidance, we will be issuing guidance, but we'll also be engaging with the legal profession as well. So I suppose it would be then the child's advocate or solicitor would be able to make them aware of their right. We've engaged, as you'll know, with a number of the youth justice organisations or the children's sector organisations as well. And obviously we'll be working with them, and they will be able to receive a copy of the guidance as well. So anybody who's representing a child will be able to advise them as well of that right.
Okay. Clause 8 on page 23. The custody officer, in taking a decision mentioned in paragraph 2A in respect of an arrested juvenile, may consider the juvenile's accommodation needs but must not refuse to release the juvenile on bail solely because the juvenile does not have any adequate accommodation. I think we all know why that's in there with regards to human rights, but can you express to the committee how big a problem this has been in the past?
And I suppose in terms of the focus behind that provision is really to ensure that individuals aren't being held solely because of the accommodation issue. I suppose at the time that provision was drafted and included in the bill, there was a slightly different position in that there was work being undertaken in relation to the joint campus. There's obviously work being progressed in relation to the Ray Jones reviews and a range of discussions and considerations going on with health at the moment in terms of ensuring that the accommodation aspect in relation to that can be provided for. That's obviously kind of the rationale behind the provisions not being commenced on royal assent. My understanding is that we're not looking at huge numbers in relation to that.
I mean, the numbers in the JJC, as you'll know, have decreased significantly in recent years. So, I mean, today, for example, there are 5 children, in the JJC. I think 1 was in PACE and 1 sentenced and 3 on remand. So you're talking about very small numbers. But unfortunately, there are cases where children are held and their bail isn't perfected because of a lack of suitable accommodation in the community. And it could be because the dispute has happened in the family home. And the police, for example, will say, well, it's not safe. They won't approve that address then as a bail address. And depending on the child's needs and how complex they are and the offending, it can take a while for then accommodation to be sorted out. Now, our view would be that a child should never be held in custody because it's a lack of accommodation in the community is the only reason. It's not for the serious nature of their offending. And that's why we had that clause in. And as Veronica said, we'd hoped that this would be addressed through the Joint Campus Programme because they were looking at satellite provision in the community and alternatives to bail. But because that programme has since been stood down, then we don't want to commence that clause yet because we don't want the judiciary to be in a position where they're having to release a child who has nowhere to go potentially. And there's obviously a safety aspect to that. So we were working with health and a number of different sort of groups and areas, and this is an issue that's constantly being raised, and I know that they're under a lot of pressure, particularly social services, in placing children and children in care as well. But we are working with them in order to identify alternatives to accommodation for these children, and once we're happy that there's suitable provision, we would like to commence that clause then.
But I suppose we were also keen that the provision in and of itself wasn't lost. Given that work is ongoing at the minute, we'd want to try and ensure that there's further discussions with health and that there's some form of resolution in relation to that provision as soon as possible. But we're equally conscious that at the moment that it isn't possible to have that provision commenced on it. It will be a future date one.
But you haven't got a commencement clause for it in the bill?
Yeah, so it's the only one out of all our provisions that will be commenced by order. The rest are commenced on royal assent 2 months after royal assent.
Right, okay. And does it say that on the face?
It says it in where the commencement provisions are dealt with. I think it's quite later on in the...
Oh, it's maybe at the back of the bill, is it?
Yeah, it'll be at the tail end of the bill in relation to the
Yes,
commencement.
okay.
And it'll usually kind of list those that are either to be on royal assent or the ones that are,
Yes.
so that's how it'll have been dealt with. It possibly won't be obvious in terms of the commencement provision that's how that's to be dealt with, but that would be the intention, as Jenny says, a
Okay, thank you
commencement
very
order
much.
for that. And obviously that's something that we'd be advising the committee about in due course
Yeah.
ahead of that provision being commenced.
Yeah. Okay, thank you very much for that clarification. That's been very, very helpful. Just then on the youth custody and supervision orders, and when I hear what you said with regards to custody care orders not being enacted, are we sure that the youth custody and supervision orders, and with the new balance or new flexibility, I should say, that's being created, is the right one? And can you explain to us as in the committee here what supervision actually means in a practical sense, as opposed to custody?
Well, supervision is then obviously carried out by, well, in this case for children, it'll generally be carried out by the Youth Justice Agency, and that means that the young person then will have to report in for certain, so say if it was 3 months on custody, 3 months in supervision, they'd be required to maybe comply with any of the requirements of the order, and that would be set out at the time when the case is sort of, sentenced as well, so they'll know what those requirements will be. But it could be anything from meeting up with a youth justice worker once a week, or attending certain, there could be certain conditions around having to attend school or be engaged in certain activities. And then there's obviously consequences if that's breached.
Yeah, and would that supervision always entail someone wearing a monitoring tag?
No, it would very rarely.
Rarely?
Very rarely, I would say.
But obviously electronic monitoring could be part of the conditions if that was deemed necessary. But as you say,
very rarely used for children.
That would be a part of the supervision terms then, but again not used for children
I would say
necessarily.
very rarely used for children.
Yeah. And then last question from me, in terms of youth custody and supervision orders, the new 3.8b on page 26, and yeah, I think you did allude to this, Veronica, youth custody and supervision order is to have effect for such period as may be specified in it, and part 3 in that is the period specified in the order may be up to 4 years in the case of a child aged 16 or over. If, and it lists out 2 pieces of legislation, Firearms Northern Ireland Order 2004 and the Schedule 2 of the Violent Crime Reduction Act 2006. Can you explain to the committee just why it's those 2 pieces of legislation?
I suppose, as we noted in those opening remarks, kind of the period for that is between 3 months and 2 years. For 16 and 17-year-olds, it can be up to 4, and it's those particular offences that are being covered in terms of being some of the more serious offences. Jenny, my understanding is that reflects what's in current provisions in relation to the current order.
Yeah, well, we just set out that one because, as Veronica said, under a youth detention and a youth offender centres order, a 16-year-old can be sentenced to one of those YOC order, and that can be up to 4 years.
Yep.
So that gives the judiciary the ability then to sentence a young person under that order for up to 4 years. But because we're removing 16 and 17-year-olds from the scope of young offender centre orders, they will only then be able to, for less serious offences, able to receive the new YCSO. But there are certain offences, such as the firearms and the other one that's mentioned there, that have a minimum term of 3 years for a person aged 16 or above, and that's why we've had to include that. And so there needs to be scope to allow a sentence of up to 4 years for certain offences.
But it's already existing practice, so is there a piece of legislation that you toyed with putting in, or is it just basically
They were
a
the
read
only
across?
ones I think that we identified that between 16 and 18-year-olds there was a minimum term of 3 years, so that's why we've included those. But I think there's also scope for additional then if any other offences similar were to be added on after the legislation is introduced.
Right.
But yeah.
Okay, well, thank you very much for answering those questions. I'm going to put out to members. Emma?
Thank you, Chair. Thanks very much to you both for coming in. I kind of want to go back to one of the questions that the Chair had covered around clauses 5 and 6. And I know that there's a response in our pack from the department on some of this, but I wonder if you could provide some clarity just around. So we've got, I suppose, concerns expressed by the CLC around some of the wording about causing a threat to public order or individuals. What way is it? Individuals that a person is involved with. Causing a threat. I'm concerned that's open to interpretation as to is there a fear there that somebody who's been coerced into criminality is at risk?
I suppose in terms of those provisions, as Jenny had mentioned earlier, those are intended to deal with those most serious offences and where there is either a risk that there would be that adverse response from the community, which would cause public disorder in relation to the incident that has occurred, or if there is a risk in relation to the child themselves causing that. I suppose in terms of looking at the individual circumstances of the case, a prosecutor as part of that process will obviously want to take into account whether or not there has been coercion of that individual in relation to the undertaking of that offence. But I suppose the focus of those provisions is really intended to be around those most serious of offences where there is either a risk from in terms of the reaction from the community, or there's a particular risk in relation to what the individual that's being charged with the offence may undertake in relation to that.
Yeah, is there a risk that there's limited protection then for somebody who's been exploited or coerced?
I don't think so. I mean, one of the things about, I suppose, having that provision in is that allows police, if we're talking particularly in relation to police bail, it allows them then to put in conditions of bail which might protect that young person. So it could be that then their bail address will have to be, they'll have to move to a different bail address, for example, one which is outside the area for which maybe that threat is occurred or is more prevalent, and the same with the court. So I don't think that there's any risk from these. I mean, the whole intention of our provisions is to keep children out of custody where we can. So, we're not doing anything here that would be more likely to end up for a child to end up in custody because of the actions of themselves or others. So everything really is aimed at keeping children out of custody wherever possible and protecting children as well.
Yeah, it's just, are there human rights implications there of somebody who has been coerced that they're further criminalised as a result of?
I don't think as a result of our provisions, no, that there wouldn't be. I mean, this
has there been engagement with the
Human Rights? Well, I suppose the bill was, processed and it was screened for any impacts on human rights, and there'd been nothing identified.
It's just that some of the concerns that are in our pack from the Children's Law Centre, the response from the department seems to say, well, that most of these provisions are in existing legislation, as opposed to a rationale that proves their worth. Sorry, I'm coming to
Yeah,
this
I think you're
late,
talking
but-
more then about the provisions that are around sort of whenever they're considering a person's right to bail or conditions, that they're looking at the nature of the person and their community ties. Is that the kind of thing you're talking about?
Yeah, so, well, the
Yeah.
way that I'm reading that, like the character
Yeah, character and
associations, community ties, well, surely that would be something that would, in an awful lot of the time, be dependent. For somebody who has been coerced into criminality or coerced into an offence, they're going to have those community ties. So
yeah,
are those things...
I suppose they're just considerations, and as the Chair had already alluded to, they're already in Article 39 of PACE, and I suppose we have replicated them here, because those are things the police will take account of whenever they're considering the wider picture around the child.
Yeah, so that's kind of exactly my concern. They're already in Article 39
Yeah.
of PACE, and as I understand it, the purpose of this bill is to update and improve, moving away from just the PACE guidance and allowing the police a more, I suppose, compassionate or human rights compliant.
I know,
means
I
of dealing
suppose
with.
our point is, I don't think that taking those things into consideration necessarily is a bad thing. It could be for the benefit of the child, you know,
Okay,
as well.
so it's kind of open to interpretation, is it?
Yes, that could be.
I suppose in terms of the provisions being brought forward and the way in which they're structured, the focus is very much, I suppose, on trying to ensure that as wide a range of factors can be taken into account as possible, reflecting the individual circumstances of the case and any things that are pertinent in terms of the decision that the police would reach in relation to that individual case. As Jenny says, the focus is very much on trying to ensure, and the provisions that we're bringing forward are intended to try and ensure that children aren't going into custody, you know, that they are being provided with bail, you know, and that we can take account of as many of those factors as possible. And I suppose given, you know, increased flexibility and increased scope in terms of what can be looked at.
And that's why we've added in then around the age and maturity and needs of the
Yeah.
child as well, you know, into that, because that's something that we're asking the police then to consider. I mean, they do it probably already, but just...
Yeah, I think it's probably that's the kind of worry, that it's open to interpretation. It's the way that you read it, because for me, looking at a young person, if they're coming from a community or have community ties to, like, depending on who, like armed groups or paramilitaries or whatever the case may be, my immediate assumption would be that child is vulnerable and has probably been exploited. The worry would be that would be looked at, and the way that it's worded around, you know, the risk, you know, it seems to assume that because of those ties, you know, so it's just supposed to clarify that, and particularly when it had been pointed out by the Children's Law Centre, and the response seemed to be very much, well, this is the status quo. So
Well, I think obviously we're adding it in relation to bail conditions, just in relation to PACE, and I suppose we're thinking then that the judge could take it into consideration and obviously put in place protective measures
yeah,
as well.
well, that would be the hope.
To keep the child from maybe encountering those people then when they're out in bail, you know, and keep them away from those sort of factors as well, rather than anything else.
Thank you. Thanks, Chair.
Brian?
Good Chair, thank you for the information. Looking at Clause 8 again, I'm just trying to understand the practical outworkings of this, that must not refuse to release a juvenile on bail solely because the juvenile does not have any or adequate accommodation. Just understanding the practical outworkings of that. I mean, so this would be circumstances where a juvenile is a suspect or has been charged with an offence, but in circumstances, either because they say they're homeless or they don't have what is deemed to be a place of safety, and it might be circumstances in which the custody sergeant or whoever is thinking of the best interest of the child. But presumably it could be the case where the child even wants to stay in accommodation, to be kept in remand, but it doesn't want, the wording is cannot refuse to release the juvenile. So presumably that would be that they do want to leave, or their legal representative wants them to leave. But if I presume there is a certain duty of care, you know, on the justice system. If someone has been arrested, but there's concern either for their safety because what allegation is about them, or about their home circumstance, or if they're genuinely homeless. And does this clause actually mean that the responsibility falls back on the justice system, or does it fall back on other statutory service, on social services, or whoever? Just so the consequences doesn't have to be almost creating another form of accommodation which isn't custody, but is a place of safety. And because one could imagine there might be emergency situations late at night where it might be actually be in the best interests of the person to be kept overnight. So it's just knowing where the duty of care responsibility ends up.
I suppose ultimately we're keen that when these provisions are in place, and what we don't want to have is a situation where individuals are being detained in a custodial environment when they should be being released, and provision being made for them in other accommodation. A key element of that, as we say, is going to be those ongoing discussions with health in terms of ensuring, in order that provision can be put in place and can be commenced, that there is appropriate accommodation for those individuals to go into. And I suppose we're conscious that at the moment we haven't reached the point where there's effective provision in place in relation to that appropriate accommodation, adequate accommodation, to ensure that there is that duty of care in relation to that young person, and ensuring that they are, there is a place of safety provided and there is adequate accommodation. So I suppose that's in part the reason why the provisions aren't being commenced at this point, so that we can ensure that when they are brought forward, that the necessary arrangements are in place, so that individuals aren't being kept in custody where there is no, justice reason for them being retained in that custodial environment.
Yeah. But to give a scenario, if the individual lives in the family home, an incident has occurred there, they're a suspect of a crime, because of maybe anger in the situation, it's not safe for them to be returned to there. It's late at night, somewhere needs to be found for them to go. It might be in the case, look, let them stay in custody overnight till things are sorted out, or where does the responsibility end up? There's a need to find somewhere for them.
In terms of the provision of that accommodation,
it ends up with social services, does it?
Yeah, it would ultimately be with health. To source that accommodation and have appropriate accommodation in place for them to go to.
I understand the idea for them not to be in detention if it's deemed that they're eligible for bail, but I am thinking at times it might be just a duty of care and a safety concern for the individual.
Obviously that would be paramount in terms of those deliberations on ensuring that there is appropriate provision in place for that accommodation. We want to ensure that ultimately individuals aren't being held in custody, as you say, but that there is appropriate provision made in relation to safe, secure accommodation, and there will be instances where you say that is going to have to be provided at quite short notice late at night. And I suppose until those discussions have been bottomed out and appropriate provision has been made with health colleagues, is the reason why the provision isn't being brought forward at this point.
Yeah, and the final thought is just like, if legal processes are working and a solicitor gets permission for the person to be released at 2:30 in the morning, is it not better just let them carry on if they're sleeping in a detention cell and sort it out, arrange somewhere else in the morning, just so there's not whatever triggers the bail decision, that there's some practical outworking of that, rather than having somebody then legally, there's going to be a court case or there'll be a statutory offence created if they're not released. Okay, thank you.
Annie? Annie, you hear us? Still on mute. That's it.
Yes, thank you. I'll start off with a wee easy one. I just on the back of how we use the word juvenile in the bill. Could we replace that to child?
Yeah, to be honest, it would be our preference to have the wording as child rather than juvenile, and the only reason that it's juvenile in those provisions, particularly clause 4 and 5, is because we have to replicate the wording that's already used in that the original legislation. So we're inserting our provisions into the PACE legislation, and throughout PACE the word juvenile is used consistently, so we couldn't then have child interspersed amongst that. Then you have to sort of go with the language that's already been used in the originating sort of legislation. So that's why in the criminal justice 1998 Northern Ireland Order, we use child throughout. So the provisions then in the bill that will be going into that 1998 order will say child, but the other ones, because they're going into PS, have to say justice or juvenile. Sorry.
Thank you. And it's touched on earlier, but just looking your view on, given that the previous legislation refers to the best interest of children, should the Justice Bill include a new clause referring to Article 3 of UNCRC? And do you think in general that the Justice Bill could be strengthened by referring directly to Article 37 of UNCRC?
I think in terms of that provision, that's not something that we as a department would have an issue with such an aspect being included within that. I suppose we'd had conversations with Legislative Council in relation to the inclusion of reference to the best interests of children, and I think they were of the view, given the nature of the provisions that are currently there and other existing legislative measures which refer to the best interests of the child, that it wasn't necessary for the bill as such to make reference to it. But Jenny, am I right in saying it's not that we would have any objections to that, but I think the view was that legislatively it's unnecessary.
Yeah. When we drafted the instructions, we had wanted it included, but we were more or less, not told we couldn't, but quite strongly advised against it, because it's at Article 53 in the 2002 Act, basically requires that wherever any bodies or functions are exercising anything in relation to the youth justice system, that they do so with the best interest of the child as a primary aim. So we were told that was an overarching principle across the whole youth justice system. Therefore, it would be duplication to have it again in relation to these provisions. But we have no objection. I mean, I said it was something that we had wanted originally.
Okay. No, that's very useful. That's all for me. Thank you.
Okay, Danny, thank you. Patsy?
I'm online here.
That's you. Go on ahead.
Chair, that's me now. Thank you, Chair, and thank you for the presentation. I just wanted to come back to the issue of children in custody there and not having a safe address to be released on bail to. Could you just talk me through the existing arrangements? What happens currently in those instances? Is it a case that police liaise with social services and hope that a location becomes available, or because obviously you don't want them, if they're not at a risk or at risk, either to themselves or others, you clearly don't want them going back into custody.
So, as far as I understand, when it comes to police bail, it's obviously less of an issue because it's generally only for an overnighter. So what they'll do is then, if the police will try their best to try and get the child accommodated outside of custody, but if they can't, then what they will do is they'll generally either bring them to the Juvenile Justice Centre, which is a designated place of safety, or else they may, on occasion, depending on the distance and the time of night, they may hold them overnight in the police cell. When they're in the Juvenile Justice Centre, if bail is agreed and perfected, but can't be perfected because of a lack of suitable accommodation, we know that Youth Justice Agency and their staff work very closely with the social services and do everything they can in order to try and identify a suitable address, within the shortest possible period of time. Now, for some children, this can be more difficult than others. It's sometimes the complex needs of the children who are currently in the Juvenile Justice Centre mean that it's very difficult to find a suitable placement. As soon as they would like, but they do make every effort, and we know that social services really do try as hard as they can to get something sorted, and the Youth Justice Agency staff work with them very closely as well, and with the families, in order to try and ensure that bail can be perfected as soon as possible.
Yeah, thank you. But you're saying that they make every effort with what range of options? Can you give us any insight into that, please?
Well, I suppose that's more of a Department of Health. I'm not sure what the options exactly are open to the Department of Health and Social Services. I mean, it may be that they will be trying, obviously I would imagine that family members would be approached first of all if they can't return to the family home. Okay. Otherwise then it would be, if it's not a child who's already in care, then they'll look at fostering arrangements as well, emergency fostering. There's a bail fostering scheme that's sort of available within the Southern Trust area, and that fostering family just takes children who are on bail for that period of time that's needed until their case is heard, or until they can return to the family home. And then maybe in extreme cases, I suppose, if they aren't a looked after children, they may become a looked after child, and it could be a case of that they could end up, being sent to a residential home. And
I know this is probably taking into the remit of health, as you've outlined there, but is the Southern Trust the only trust that has that type of arrangement for children?
At the minute, because the Southern Trust piloted the bail fostering scheme,
All right.
and now they've actually mainstreamed it because it has been successful. They have a couple who
Okay.
fostered 5 children during the period of the pilot, which is 18 months, and they've worked out very well, so they're now mainstreaming that. We are in discussions at the minute with colleagues in the Department of Health in order to try and see if we can extend that pilot beyond the Southern Trust. Unfortunately, the remaining trusts aren't in as good a position in terms of their foster parenting capability, or in terms of their capacity at the minute, and I know they're struggling. But we are looking to identify another trust at the minute, which could be, maybe the next one in line, that we could try and pilot it there as well for a while, and then hopefully we would get it extended across the region eventually.
Thank you. And Chair, just one final question. Are you finding that there are increased numbers of children who are A, find themselves in those situations, and B, requiring that type of need?
The numbers in the JJC generally have gone down a lot, and they
Right.
are very small. Unfortunately, that means then the children who are there probably have more complex needs than you would have had, 15, 20 years ago. So in that way, it can be harder to try and find them accommodation if there are issues. But I
Okay.
wouldn't say no that there are increased numbers. I would just say that the complexity of the needs maybe is greater.
That's okay. Thanks very much indeed. Okay, Chair, thank you.
Hey, Patsy. Ciara?
I just wanted specifically in relation to accommodation as well, because obviously we are concerned that it'll be through an order and it won't be commenced. So just could you kind of highlight for me, essentially, you mentioned, and I didn't hear it, sorry, that a group had stepped down, that the Department of Health had a group, but it was stepped down. And that's obviously delaying looking at this intensely and trying to ensure we do have the appropriate accommodation. What was the name of that group? And then obviously, secondly, do you believe that there could be an opportunity through this legislation that it was more clearly defined, that there is a statutory duty, like basically for the bail address and for the court to be updated by relevant health trusts as to the progress in providing the bail accommodation by attendance of trust personnel at court, would definitely give greater protection for children in the implementation of it as and when it is implemented.
I was just going to say, in terms of, I suppose, the earlier piece of work that was being taken forward on why that provision was originally being included in the bill and was obviously in an earlier version of the Justice Bill, was when work was being taken forward in relation to the joint campus, so bringing together the health and justice aspects. It's I suppose that piece of work that was stood down and that programme of work wasn't necessarily being progressed to the same extent. There are obviously ongoing discussions in terms of the outworkings of the Ray Jones review, and we continue to have conversations and discussions with health colleagues in terms of how best this can be progressed. Obviously, from a justice perspective, we would be keen to see these provisions introduced as soon as possible, but are very conscious that we are dependent on the health aspect and the provision of the necessary accommodation in order to get that work taken forward. I'm not sure if there was or if you know, Jenny, if there was a particular group that was looking at that, or the name of that group?
No, so it would have just been the Regional Justice and Care Campus Programme, but a subsection of that programme was looking at alternative provision in the community and satellite provision and alternatives to bail as part of that. And I know that it didn't progress very far, I think just because of the difficulties, because we're talking about such small numbers of children and trying to find regional provision, and have something in place all the time, 24 hours a day, I suppose, just in case it's needed at the minute, because of pressures on particularly the health sector and on our own budget as well. I think that there were no easy solutions, I suppose, so that work has not really progressed.
And as you say, in terms of the numbers that we're looking at, the figures for today are 5 that are being held in the Juvenile Justice Centre, so they are small numbers that are being dealt with. In terms of the query around the health staff being available at court, I'm not sure that it's probably not something that we as officials in the Department of Health or in the Department of Justice would have a say over. I'm not sure, I suppose, as well how practical or feasible it may be from a resourcing perspective from health colleagues. And I'm not sure if it's something that's been raised with them at an earlier point in discussions. My sense would be that they would probably consider, they likely wouldn't consider it to be a feasible approach.
Given the pressures on social services side, I would say that you would probably face a bit of a kickback from them in terms of that. But I do know that the YGA have a bail support scheme that's offered to children who are held in the Juvenile Justice Centre and who are granted bail but are having problems in terms, and they work very closely with the Department of Health as well in order to resolve. So I don't think it's a lack of willingness or effort on the Department of Health and Social Services to try and find places. I think it's a wider issue, so I'm not sure if having somebody there in the court, would help that, because I think they're doing everything they can. I don't think it's a lack of effort on their part. It's probably a resourcing issue and capacity issue.
I suppose just to come back on that, we all know clearly a huge capacity issue in relation to housing in general and accommodation in general. And I'm just conscious we have this in the bill, but how realistic is it in relation to a timescale for implementation? It's just my concern, that it's just on paper, but it actually really doesn't mean anything unless there's a concerted effort. There's a task force set up, and I get it regarding resources, but you say it's a small number. So it's quite a unique project with unique resources for a small number of young people, but to try and ensure that particularly our most vulnerable children who should not be in remand and should have suitable accommodation. It is quite urgent if we're going to have a children's right approach to this. So I would just love to get further detail on what's your thoughts. Is there a working group going to be set up? Is there one already? Where's the focus on it? What's the resources that is required? So there's more detail around the urgency of it, and likewise when the minister is likely, in all likelihood ever, to be able to implement this.
I suppose in terms of the provisions that are currently in place, there isn't a working group as such set up in relation to this piece of work. There are ongoing discussions and engagement between the officials in both department, and there's also engagement between officials in Youth Justice Agency as well as our counterparts on the health side. Certainly we as a department would be keen to see this introduced at the earliest possible opportunity. It's never a good situation to have legislation on the statute books that hasn't been commenced. So there certainly will be a drive from and a focus from a Department of Justice perspective to try and ensure that those lines of communication remain open with colleagues in the Department of Health, in order to try and get a resolution in relation to this.
I mean,
and have you any indication from the Department of Health what a timeline would be for the minister?
We don't have any, but I mean, we have been discussing with them around the bail fostering. So the bail fostering scheme, if we can get it extended, but it will be probably on a slower trust by trust basis until it's operational throughout Northern Ireland. So that is a possibility. And there's also a piece of work ongoing. There has been a task and finish group set up as well to look at issues around children who are in care, who then end up in custody, in order to keep them out of custody as far as possible. So it's working with the trust, working with the police, in order to ensure that they just don't go in the first place, in order to prevent things from escalating to such a stage that the child ends up then, committing an offence, and the offence actually getting as far as the court as well. So there is an ongoing piece of work on that as well, which should hopefully reduce numbers.
Okay, thank you.
Morris?
Thank you, Chair. Just a wee quickie, and it's in clause 7. Will data be collated in clause 7 or monitored or to identify if there are any sector of particular children from a childcare experience or vulnerable society that seems to be more prevalent to be in trouble with the police?
We should be able to get information out. At the minute, there is information collected by the Youth Justice Agency staff in relation to breaches of bail and how many of those breaches then end up back in court on pace or on remand as well. So those numbers thankfully are declining sort of year on year. As this is becoming more practice for police, they're not necessarily now always or arresting a child and bringing them to court for breach of bail. So what we've sort of made a provision for here reflects a lot of what's happening currently in practice. So we would like to see then, once this introduces a further decline in the numbers of children then who are brought back to the JJC because of breach of bail, and that'll be able to let us know if it's working.
That data will be collected.
Yes, it is collected.
And assessed. That's all right. Thank you, Chair.
Okay, that's all the members then that wants to ask questions on the children's part. Could I be so bold to maybe go into before we get into the restorative justice scheme, the criminal age of responsibility, and how that then impacts on part 2, if that was to be, if the amendment and any other potential amendments that maybe lay down how that will impact on part 2.
So in terms, there's obviously the amendment that's been put forward at the moment in relation to the age of 14 with the exceptions. As you say, Chair, there may be further amendments in relation to that, and I suppose a number of different options among a range of groups out there in terms of what their preference would be. I suppose we're aware that a large number of the children's related groups would be keen to see the age set at 16 as opposed to 14, or if it was for those that are that want 14 in place, that it's 14 with no exceptions. In terms of the wider provisions of the bill, as far as I'm aware, there wouldn't be any ramifications from an amendment being brought into the bill more widely, so it would effectively be a standalone clause, and then it would be the outworkings in relation to that provision that we would be looking at, but there shouldn't be kind of cross implications in terms of provisions that are currently in the rest of the bill in relation to that.
Would you mind if I put it out to the members to see if there's anything on this?
Yeah, no, that's no problem.
With that? Does any member want to ask a question around the criminal age of responsibility amendment? Brian and Emma?
Yeah. Yep. My main question is what happens if a child under the age of criminal responsibility commits an offence? Is it not deemed an offence because of their age? And what input does the criminal justice system have? And in terms of providing justice for the victim of whatever has occurred. Does it mean that if the child is under the age, the criminal justice system, it's a get out of jail card in terms of not just jail, but the whole criminal justice system? Or are they still obliged to take part through the Youth Justice Agency in a process?
And I think that's something
recognising that an offence, that a victim has been created, an offence has occurred.
I think that's something that Stephen Martin, the Chief Executive of the Youth Justice Agency, helpfully touched on last week. Obviously, in terms of the criminal justice system, if the age were changed to, for example, 14, there wouldn't be there wouldn't have been deemed to be an offence for an individual who's currently aged between 10 and 13. I think Stephen was quite keen to emphasise that it's not that there wouldn't be anything done in relation to that child, because I do think there also needs to be an acknowledgement in terms of what has occurred, and as you say, there will be an individual where harm has potentially been caused in relation to that other party. And Stephen did seem to be indicating, and something that would have to be further considered is in terms of how those children would then be dealt with, what the role would be for social services, what role, if any, there would be for the Youth Justice Agency. Again, I think Stephen was quite keen in terms of his comments that there would possibly be an involvement of the Youth Justice Agency on a voluntary basis. It obviously would no longer be on a statutory basis, but it's not, there wouldn't be as such a get out of jail free card. It's not that there wouldn't be consequences, for want of a better phrase, for that individual. I suppose it would be it would be looking at it in a more age appropriate manner, and seeing how most effectively that child could be dealt with in terms of kind of the behaviours that have been demonstrated and what has given rise to those behaviours in the first instance. Jenny, anything else?
No, just to say I agree with that.
Yeah. And that's why the Youth Justice Agency exists, because it does deal with youth offending in an age-appropriate manner, and everyone would recognise it's separate to how an adult should be treated, and it's an appropriate level. But there still needs to be an intervention. If what is, in all intents and purposes, a crime has occurred, and that there's been damage caused to the victim of a crime, and someone needs to be supported also to reform themselves and not engage in that again. All the things that the justice system aims to do for adults and children. But even under the current system, those currently below 10 are still subject to some intervention and support to reform themselves. So there still is there is currently a difference of approach, and under the Youth Justice Agency up to the age of, I presume, up to the age of 18, that they do give an age appropriate intervention.
I suppose if there were that change in the minimum age criminal responsibility, the outworkings of that would have to be considered in terms of the practicalities on what those interventions may look like, who may be involved, the appropriate agencies that would be engaged with in terms of taking that piece of work forward. If an amendment were brought forward and were voted through, it's likely that would be a provision that would be put in place by way of commencement order in order to allow those further pieces of work to be undertaken. Obviously with a view to having any provisions commenced as soon as possible, but there would be work to be taken through in terms of what does the outworkings of that look like and the operationalisation of any new provisions, and as you say, in terms of there being interventions or work being undertaken with the individuals that have been involved in the incident, albeit that it would no longer be a criminal offence as such.
Yeah, well, that's my last concern. Is it not considered then a criminal offence because they're below the age of criminal responsibility? What is it deemed then to be? What is it called?
I'm not sure if there's a particular term used.
I suppose it's the same now if it applies if a 9-year-old or 9.5-year-old committed an offence, it's not considered an offence.
But it has caused damage to someone. It is something that otherwise would be a crime if they were above the age. That's my concern about the public messaging of it. That in terms of individual responsibility and good behaviour, bad behaviour, whatever way one deems it, it can't be called a criminal offence.
I suppose it's not that we're saying that there wouldn't be consequences for individuals and that there wouldn't need to be work undertaken with them and looking at what might be appropriate for them, what the cause of the behaviour has been, etc., how best that can be addressed. I suppose it's about dealing with it in a child appropriate way, given the nature of the particular incident and the seriousness of what has happened and the harm that has been caused to that other party. It's about, I suppose, responding to and dealing with that particular incident in a slightly different manner, albeit, and again, I think if there was the involvement of the Youth Justice Agency to a certain extent in relation to those types of incidents going forward, if that change were made, it would be building on the good work that they already are doing in this area, albeit, as Stephen was alluding to, it would be on a voluntary basis as opposed to a statutory basis.
And sorry, last question. Their current remit is for what age group? Not to 18, not to 17?
It would just be the age of, so current age criminal responsibility is 10. So it would be 10 to 17.
They currently wouldn't engage with someone.
I think maybe they can do it on a voluntary basis if there was a case made. But I would say it's very rare they would deal with under 10s.
Under 10s would be social services more so?
Yes, it would be.
Okay, thank you.
Okay, Emma.
Thanks, Chair. And I'm just new to this committee, so I know there's been an awful lot of back and forth around this and the provisions of the bill and the conversation around lowering or increasing the criminal age of responsibility. And I suppose it goes back to the conversation that we had earlier and around the fact that, there's almost like, to me, there's two ways of looking at this. There's quite a punitive way in saying, oh, well, somebody has had a series of offences, criminal offences, incidents, caused harm to other people, as the previous contributor referred to. So that's an indication that they're likely to commit crime later in life. And then I suppose there's a more compassionate approach, which, to be honest, I think is more appropriate, where more than likely that person has extenuating circumstances in their life and things have happened, and by criminalising them and going down that route, more often than not, you're sort of writing the script for them, whereas with a bit of support and help and compassion, things can turn around.
We're obviously, we're very conscious in terms of, and as you allude to, the younger age at which individuals are brought into the criminal justice system, or there's engagement with the criminal justice system more generally, there's an increased likelihood that they will then end up coming back into to that system. And I suppose in terms of any change to the minimum age of criminal responsibility, it's about trying to look and see, is there a more appropriate way in which those incidents can be dealt with given the particular circumstances of the young person at hand. And I suppose it's also reflecting that in terms of the cases that are going through the system currently. The vast majority of those that are ending up in the Juvenile Justice Centre with a custodial period of time in that centre, the vast majority are in that older age group. I think over the last 6 years, have we had either one or two that were aged under 14 and they were on the cusp of reaching their 14th birthday. So to all intents and purposes at present, custodial sentences are not being given for the age group that we would be talking about. You know, if that amendment were passed, custodial sentences are effectively not being granted, or certainly not in kind of recent years. They're generally speaking not being granted for those individuals that would be removed from criminal responsibility if that change were to be taken forward. And again, I suppose there is also the fact in terms of the amendment that has been tabled at the moment. I suppose it's trying to, it could be seen as providing something of a balance between having, you know, the age of criminal responsibility change, but also an element in relation to the fact that there are concerns from a number of people about those most serious offences, so murder, manslaughter, rape, or the types of categories in terms of the current amendment that would be accepted from that. But as I say, I suppose any change in the minimum age of criminal responsibility, I suppose, would to a certain extent reflect the way in which cases are being dealt with at present going through the courts, and the fact that so very few for that age group are actually ending up with a custodial a period in custody as a result of
if I could ask the question, it strikes me that there's an education piece needed. I had a particular concern around young people. You see the rise of like online, I mean, there's social media has become a hotbed for misogyny, for racism, for sectarianism, homophobia, all of the isms in one place. And you're having young people who are exposed to those mindsets and that sort of ideology, and like we all know, toxic group chats and that sort of commentary. And they haven't maybe done anything, but you give that mindset a few years to grow, and then by the time they are an adult, it has reached fever point where, you know, it started as, you know, jokes with jags or misogynistic comments for an example, and by the time they're in their 30s, they're battering somebody to death. So that to me is the priority, as opposed to criminalising people who have done something inadvertently, or you know, a bit of peer pressure, or got caught carrying on and sort of a low level. So that's I suppose, is there cross-departmental work going on there, or something around engagement with young people about the harm of those mindsets and how that can bear in?
I suppose in relation to that, the area that we probably would see that being taken forward most is in relation to the anti-violence against women and girls work that's being progressed. There's obviously there's been a range of advertising campaigns being taken forward with them, and there would be very much a focus in terms of that piece around trying to change mindsets, trying to educate people, trying to ensure that, I suppose, you know, that toxic or those misogynistic or, you know, any of those other traits, that, you know, those are called out at as early a stage as possible, but it's being done kind of across the board, I suppose, both in terms of trying to change behaviours and attitudes and raise awareness in terms of younger people, but also what changes can be brought about or could be introduced and addressed in terms of the wider adult population. Obviously, the earlier that is possible to get in and try and tackle and address that, it hopefully prevents it then you know, escalating and becoming more problematic as individuals go from you know, from those teenage years through into adulthood, but also, I suppose, a piece of work in terms of trying to address those issues more generally is very much a focus of their work, and that is a cross-executive programme that is being taken forward. You know, the Department of Justice is involved in it, Department of Health, Education, etc. You know, there's a wide range of departments being involved or that are involved in that piece of work being taken forward.
Plus, I suppose the Youth Justice Agency as well do a schools programme, you know, and they go out to a number of schools across Northern Ireland as part of their work programme and talk to them, young children, about the dangers of things like sexting, different social media sort of things that they could be, obviously, you know, crimes that could be led into, but also drugs, alcohol, all the whole range as well. So that is a prevention programme that's, you know, undertaken by the Justice Agency.
Yeah. He's probably for wider society there. Thank you.
Doug?
Thank you, Veronica. Jenny, thank you very much. Two very direct questions, and I'll give you them both if I can. First of all, if we raise the age of criminal responsibility, I take it there's no inability for the police to still arrest a child below the age of criminal responsibility in order to invest in an investigation.
I don't think they would be able to arrest.
No,
they would be able to interview probably, but it would be on a voluntary basis, I would imagine.
Yeah, if the age of criminal responsibility was raised, there wouldn't, as we said, there wouldn't be a criminal offence committed. Therefore, yeah, police couldn't arrest and charge as such.
Okay, so I didn't get to my second question, but I'll just go to that one as I've got it and expand it a little bit. So how do we know it was a child if there's no proper investigation? So what if a child commits a crime? We think the child's committed the crime. The child's below the age of criminal investigation. They're not arrested. They're not investigated. We accept it was them. But what if they were coerced by somebody else? Somebody else did it and said to them, you take responsibility. How do we get around that if there's no investigation?
I'm not saying there wouldn't be an investigation, but I just think the police wouldn't have the power to arrest.
Yeah.
But I think they would be able to interview a child, but it would probably have to be on a voluntary basis, the way interviews are currently carried out with children.
I think it'd then also be looking at what we were talking about earlier in terms of if for that group aged 10 to 13, how are those incidents dealt with? What is the role of social services? What may potentially be the role of the Youth Justice Agency on a voluntary basis? So I suppose it's not that there wouldn't be some form of consideration of what has happened and outworkings in relation to that in terms of that young person, and again would likely reflect the nature of you know what would have otherwise been a crime, the seriousness of that. So I suppose it's other ways and means in which we would look at how those cases could be dealt with.
I kind of get all that. I don't think that's necessarily the point I'm making. The point I'm making is, what if the child has taken the rap for something it didn't do? And if they don't have to turn up for an investigation, if it's voluntary and they say, well, we're not turning up, how do we figure out that actually it wasn't the child that did it, but it was an adult, a 16-year-old or 17-year-old who did it, but asked the child to take the rap for it? How do we get round that if we don't arrest and investigate in order? And if you're saying it's voluntary, it'll be voluntary unless you're arrested. Do you see the point I'm coming? How do you stop somebody abusing? Because this was my second question. My second question is there an offence of directing a child under the age of criminal responsibility to commit a crime?
I'm wondering, Doug, and it's
because, sorry if I can, because at the age of 10 it's not such a big issue. The age of 14, I'm telling you now, it is.
There may be, I'm not sure if there's anything in terms of the organised crime provisions that may assist with that in terms of there being individuals who are making use of others generally, you know, for criminal purposes.
I think in the crime and policing bill, isn't there stuff around child exploitation and coercing the children?
Yeah, I suppose
And
it would
being an
probably
offence?
come under your child exploitation provisions more generally.
Yeah.
I wouldn't be over the detail of what those look like.
But you can see what I'm getting from the two aspects here. I never seen it really as an issue with a child at the age of 10 years of age. You know, it's not likely. But so a child at the age of 14, for example, 14-year-olds are far more linked into society through social media. I think Emma makes a really good point, through social media and other things. And adults or older children above the age of criminal consent, 16-year-olds and 17-year-olds, still a child as we're trying to allude to here, can always get that young person, that 13-year-old, to take the responsibility for something they did not do.
If it was a fairly serious offence, you know, then there would definitely be social services involvement, and you would imagine that would come out in the course of discussions with the child. And as I said, police can interview a child, but they probably wouldn't arrest them. But I know the police generally don't tend to arrest children anyway, unless it was for something very serious.
I suppose as part of the investigation more generally, as you say, Jenny, if it was more serious level offences, there would be a consideration given to who all has been involved, who has applied pressure, who may have been, directing this or have been involved in the criminal offence more generally. So some of that information, I suppose, would potentially come out as part of those wider criminal investigations. I suppose it just wouldn't necessarily, it wouldn't rest with that particular child in that instance, but you would like to think that as part of those deliberations there would be a finding in terms of where has been the source of this here.
And I'm not labouring this, I'm sorry, but I'm just trying to get my head around it, because I just see a loophole here. I genuinely do, and that is people directing people under the age of 14 to conduct crimes or take responsibility for crimes that they have committed, and if there's no ability to arrest, to investigate the child, to eliminate them from the crime, say, actually, it wasn't you, son, away you go, it wasn't you. That's important, because there's still a victim out there. It wasn't you, so somebody else did it, let's find out. And if we don't have the ability to arrest, to investigate, to do that, we're not going to get to the bottom of that. And as I said earlier, there's a victim at the end of this. So I'm just concerned about that. And look, I think you've answered me well, but I just thought I'd raise that because it's something I'm certainly concerned about.
Under the child criminal exploitation, all the provisions around that, there'll definitely be something around that.
And the wider police investigation in terms of looking at all of the particular factors of the case. But
and obviously we'll be looking to with the likes of Scotland, obviously they had increased theirs to 12, and there's serious consideration being given to increasing it now to 14 as well in Scotland. So we'll be looking to them, as well, to hear any learning that they have, especially around how you would deal with offending behaviour amongst.
I just feel that there's certainly a wider conversation to be had here, because the way society has changed. I'm not against increasing the age of criminal responsibility, by the way. I'm just looking at how this affects in the wider society that we have. How many people, or how many children under the age of 14, for example, today are committing crimes, small crimes, petty crimes, but crimes nevertheless where there's a victim. And it'd be really interesting to get the statistics of what that is, because we're about to take that cohort out of the criminal justice system completely. So it'd be interesting to get that.
Yeah, and I suppose that's also linking back into the information in terms of the number of children aged 10 to 13, essentially no children aged 10 to 13 are ending up with in custody, which will be your most serious offences, at present. Obviously, as you say, there will be those lower level offences that are being committed, but over the past number of years, literally no children have got a custodial sentence that are aged 10 to 13.
And I wouldn't want them to either.
No.
I'm just
We're
thinking,
very glad to have
I'm just
figures
thinking,
like
making
that
sure that we don't have a loophole here for older people to be able to use younger people to get out of what they've done. Listen, thank you.
Thank you, Doug. Morris?
Thanks, Chair. Something similar, and it was if the age of criminal responsibility was to be raised to 14, how many children are currently in the system for serious crimes below the age of 10, and what would the difference be currently to a projected under the age of 13 in the system, and serious crime irrespective of what age a person is needs to be investigated. But the other side of it is we don't want to have young people tarnished with a criminal record needlessly. So it's a balancing act. So if you get into that.
And in terms of, I suppose, the figures currently, as we say, in relation to those that have ended up with a custodial sentence over the last 6 years, there only have been 2 that were aged in that kind of category of between 10 and 13, and those individuals were effectively on the cusp of turning into that 14 category. I don't know if we have we don't have them to hand, but I don't know if there's figures more generally in terms of that 10 to 13 grouping and the offences that would be associated with.
Yeah, I'm not
that.
sure. I think the numbers in terms of 10 to 13 year olds who sort of would go through the court system would be maybe 200 to 300 around the region of that a year. And when you're talking about under 12s, be in the 10s, 20, very small numbers. But I suppose for the maybe 12 and 13 year olds, there'd be an increase. But as Veronica said, very few of those would be serious offenders or prolific offenders at that age. And I think really negligible numbers would end up with a custodial sentence. So you wouldn't be removing, but the remainder of those would be getting diversionary orders or community orders.
Okay, just on this, because it is a very fascinating point, and Doug has hit on a thing here. The existing Article 3 deals with guilt. So it reads, it shall be conclusively presumed that no child under the age of 10 can be guilty of an offence. But the amendment deals with charges.
Yeah.
And I suspect it's dealing with charges because it differentiates and allows a child aged 10 or over to be charged with murder, manslaughter, rape, as we've already alluded to. So it's nearly as if we've shifted the focus on the minimum age of responsibility away from guilt, but by then stopping the police acting out with regards to charges. Do you see any fundamental change in that would concern you?
I mean, we obviously weren't responsible for drafting that
No, of course you
amendment,
weren't. No, of
so
course.
you know the wording obviously has been chosen, and as far as I can recollect, that wording is largely based on the wording that's used in the South of Ireland in the legislation around that provision as well.
But there's nothing in any of these two articles, the existing one and the proposed amendment, that actually talks about arrest.
I know.
Or interview.
And I think it would take somebody from the Legislative Council to sort of, in terms of the language used and what exactly that means under the law, would need to really explain the difference and whether or not a finding of guilt, or it shall not be charged.
Yeah.
Then whether any of those really includes the whole process in terms of arrest. I mean, I know when we were drafting our provisions for the bail and remand and the custody, a lot of time and thought was given to the wording, the exact wording, and what exactly we meant and what we wanted to see, and looking at every possible scenario that could be encompassed onto that. So it would need somebody, I think, with that kind of legislative background, drafting background, to advise on that. I wouldn't be able to.
And I suppose the other thing is, if an amendment were brought forward and were passed, that's something that the department would then want to be considering in terms of the wording that's used, and there also would be engagement with Legislative Council in terms of the nature of the amendment and whether it was felt to sufficiently deal with the issue at hand. But as you say, Jenny, it's probably a legislative, and without wanting to appear unhelpful, it's probably more a Legislative Council issue or legal representatives in terms of the exact kind of nuances of the wording.
But as far as we're aware, even though our current provision says a finding of guilt, no child under 10 is ever arrested by the police for an offence.
Right, okay. Can I just, before we go on to restorative justice, can I just take you back, because I'm late to the party with regards to commencement orders. But am I right in saying that out of all the Part 2, it's only Clause 8 that deals with accommodation that you have reserved the right to commence?
Yes.
All the rest come in after 2 months?
Yes.
Right, okay. Thank you for that. Okay, then moving on then to the restorative justice amendment that has been proposed by the department.
Chair, I'll be very, very brief in terms of an overview in relation to this. So I had briefed the committee on these amendments earlier in the year, and I suppose just by way of overview, there's two key elements associated with the provisions that are being brought forward. So one of them is to deal with an oversight and transfer of policing, security and justice powers at the time that they were devolved to the department, and the associated powers relating to the accreditation of organisations currently sit with the Secretary of State with an agency arrangement in place that allows the powers to be exercised locally, so essentially being taken forward on an administrative basis under that. The provisions in the bill would obviously address that in terms of placing those on a statutory footing, and then also some changes are being made in terms of kind of the detail and scope of that more generally. So the provisions are looking at the accreditation of organisations as well as individuals, also providing for restorative justice services, and further to be a register of accredited providers similar to what we currently have in terms of that register. And it would also make provision in relation to inspection and reporting on those providers of restorative justice services, and in extreme circumstances for the removal of accreditation if that was deemed necessary. Members will be aware from separate briefing that we're looking at the new accreditation process at present. What we've tried to bring forward is a comprehensive and robust process with a new accreditation framework and practice standards in relation to that, which sets out very clearly the levels of accreditation that would apply. There are 3 tiers that are involved in that, and increased levels of training, expertise and experience associated with that as we move through from the foundation level to the the more experienced and more serious cases that we would be dealt with under that. And I suppose in terms of the provisions that we're bringing forward and the new process that is being brought into effect, is very much to try and focus on there being a consistency in terms of the level and standard of service provision, that there is an appropriate level that is being reached, that we have a robust process in place, and that we're getting the assurances and evidence from organisations and individuals in terms of what their experience has been, what level of training has been undertaken, the expertise that they have in relation to taking forward these cases, looking at things like asking applicants to set out a case study in terms of the work that they've undertaken, and also a range of kind of practice standards and requirements and declarations that are made in relation to that accreditation more generally, in terms of things around adhering to the rule of law, working with criminal justice partners, and that type of thing is covered as part of that process. Obviously more than happy to answer any queries that members may have in relation to those new provisions.
Okay, thank you, Veronica, and for that explanation. Can I go straight into 5A? The Chief Inspector must from time to time make a report to the department. Now, must in a legislation terms is very strong, but from time to time is very willy.
I suppose in terms of, and I totally understand where you're coming from in relation to that, I suppose what we didn't want was to place a specific time-bound obligation in relation to those inspections being undertaken. But in terms of the discussions that we've had with the Criminal Justice Inspectorate, and what our intention would be is that the accreditation will obviously apply for a 3-year period. The intention would be that we would have the Jenny basically undertaking an inspection into organisations and practitioners as part of that 3-year window. So the intention would be that essentially over a 3-year period there would be an inspection undertaken by Jenny, and as we go into subsequent 3-year periods that would be further undertaken. So that would be the intention. I suppose what we didn't want was to tie anyone's hands in terms of the legislation, but that would certainly be the intention from the department's perspective, and we've had discussions with Jenny in relation to that, and they seem content with that approach.
But it would be fair to say that someone could get accredited and not be assessed for 3 years.
And I suppose while that's the formal Jenny inspection that would be undertaken, we obviously have a protocol lead in place in the department who's been done an extensive amount of work in relation to this new process in terms of the drawing up of the practice standards and the accreditation framework. Organisations and covering the practitioners that are sitting under them as an organisation will be required to report to the department in terms of the work that's being undertaken. The protocol lead will also have a key role in terms of, and us as a department, in terms of looking at the service that's being provided, the quality that's being provided. We will want as part of that process to have some form of feedback from those who are going through the process, for want of a better phrase, some form of satisfaction surveys being undertaken, so that we can periodically look at and assess how that accreditation framework and the services that are being provided are being delivered. So there would be ongoing review both by the department and the protocol lead, who's an expert practitioner in this area and has worked in this area for 20 to 25 years. So there would be the work undertaken through those avenues, in addition to the formal inspection that's been undertaken by Jenny. And I suppose from a Jenny perspective, we don't think it would be feasible for them to be doing inspections any more frequently than that, to say for argument's sake to do something on an annual basis. That's not to say that because the Jenny inspection was being undertaken once during that 3-year period, that's not to say that there won't be oversight, monitoring and governance of all of those organisations and practitioners in terms of the quality of the service that they're providing.
3B, the requirements may include, this is the requirements for that accredited persons cooperate with Chief Inspector of Criminal Justice. The requirements may include, in the case where an accredited person employs other persons, requirements to be met by some or all of the person's employees or other staff. This will be included in the requirements. Does that mean that one person can be accredited and then employ as many people as they see fit? And is that currently what takes place?
So I suppose in terms of the current provision, you have accreditation of 2 organisations. So as members will be aware, Northern Ireland Alternatives and Community Restorative Justice Ireland. Under the new approach that's being brought forward, there will be accreditation of an organisation, and there will also be accreditation of the practitioners under that. So in terms of kind of the new process going forward, and obviously we're in the middle of applications coming in for that, at the moment we have 5 organisations that have applied for organisational accreditation. They will then also submit a number of applications for their practitioners. So an organisation will seek accreditation in its own right, and then any individuals within that organisation, they will put forward a number of applications for accredited practitioners to work in this field under them. In order for an organisation and the staff within it to be taken forward criminal justice cases, those practitioners will have to be accredited at level 2 or level 3.
And do you think that there should be some sort of ratio within an organisation of accredited people before an organisation becomes accredited?
I suppose there's nothing that would require, I suppose, an organisation, if an organisation is solely focused on restorative justice work, there's nothing that would require that organisation to have all of their staff accredited. What we would envisage that is over time, and I suppose because it's a new process that's being introduced, we would hope that we will build this up over time. We will start off with diversionary disposals before we move into the court sphere. Our sense is that organisations that are very, very well established in this field in the first instance will put forward a small number of practitioners for accreditation. What we would envisage is that over time, and as we take forward subsequent application periods for accreditation, is that the vast majority of those organisations where this is kind of their bread and butter work, for want of a better phrase, we would expect that they would look to have all of a significant number or a significant proportion of the staff in their organisation accredited. I suppose in terms of the process and the way in which it works is what we as a department want is to have an assurance in terms of organisations undertaking restorative justice services and the provision of those to a certain standard, and that in terms of those that are going to be taking forward the criminal justice cases, that those individuals that we have assurances in terms of the level of expertise, the level of experience, the level of training that has been undertaken by those practitioners.
Subsection 6 says the department may remove a person from the register if the department determines that the person no longer meets the requirements for registration. What sort of impact will that have on the organisational accreditation?
It shouldn't affect the organisational accreditation. I suppose both types of accreditation could be reviewed potentially depending on what the incident or what factor was being considered. So there could be a review of either organisational or practitioner accreditation, or potentially both, depending on what it was that had occurred. And obviously what we would want in the first instance, if there were any issues, and again as part of that, that oversight and monitoring process, we will want to be closely looking and monitoring the work that's being undertaken both by organisations and by their practitioners. If something were to come to our attention, that's something that would be looked into by the protocol lead. And in the first instance, the matter would be raised with the organisation and or practitioner for them to look at resolving before we would end up going down the route of potentially removing accreditation from an organisation or practitioner.
Okay. Maurice?
Thanks very much, Chair. I have concerns about the removal of Jenny's pre-accreditation role, and I can understand why, especially if they're going to be doing the inspection every 3 years. And there's under clause 26A, there's also a tendency that there could be, depending on how this rolls out, disparity or inconsistency right across the country from these organisations. I'm being honest, I'm just not 100% behind it. So could you explain why Jenny have been removed, please?
And I suppose one thing to stress in relation to the Jenny role is that we did have discussions with Jenny in terms of what was felt to be the most effective involvement of the organisation on the inspection function in relation to that. There was a concern from Jenny in terms of when they come in at the earlier stage that they haven't seen how an organisation is practising. They don't have, that when they come in at that later point and are inspecting an organisation that has been operating and providing these services under the accreditation framework for 6 months, 12 months, there is something very clearly for them to consider, to review, to identify if there are any issues, difficulties, etc. that need to be addressed. I think there was a concern from Jenny in terms of that pre-inspection function. There wasn't necessarily something substantial or material that they were able to look at and consider in terms of the delivery of services, certainly in the context of an organisation being accredited or otherwise. So that's kind of the position that was reached in relation to Jenny, having had conversations and discussions with them as to what was felt to be the most appropriate function for them in terms of that.
To you, Chair, I find that incredible, because if I were to employ 6 football coaches, I would need to see their accreditation before they would get the role. Here, this way of doing it seems to say you can have the role and we'll have a look at you in 3 years' time to see if you're doing what we think you should be doing, instead of you telling them this is what you need to do.
And in terms of that accreditation process, the framework, etc., I suppose it's not that that's not being considered or looked at, because obviously in terms of the accreditation process more generally, both organisations and practitioners, we have set out very clear standards and guidelines in terms of what they are expected to provide, the level of expertise, experience, skills, training, etc., that they will have in relation, in order to undertake this function. So there's a very clear there's very clear provision in terms of the accreditation framework and the practice standards around what is expected of those individuals from both organisations and practitioners, and for them to very clearly set that out and evidence that as part of the application process that is being submitted to us. So as part of that, organisations and individuals in different guises have to clearly set out to us what their experience is, what expertise they have, what training's been undertaken, to give us examples of the work that's been undertaken, to indicate that they have worked with, and are willing to continue to work with criminal justice organisations, in particular the police, and then obviously a range of standards and declarations that they have to agree to in terms of undertaking this function. So there's, through that application process and through the standards and the provisions that are included within the accreditation framework and the practice standards, we're very clearly setting out what the expectations are in relation to the organisations and practitioners, how they need to evidence that to us, and then the CJINI role is really coming in and looking at how the delivery of the services has been adhered to in terms of that framework and the practice standards.
Thank you. It's just my opinion. I think it's too loose for such an important role. I don't think there's enough scrutiny at the start of it, not during it.
And I suppose in terms of the process that's being put in place in relation to this, obviously, as we say, we have the protocol lead who's been an expert in this field for 20-25 years. They will be considering the applications that are being put forward, the evidence that's being submitted as part of that process. We'll also have an independent suitability panel, which will involve, again, 3 independent expert individuals who have experience in the restorative justice field. The chair of that suitability panel is the person who was chair previously, and we also have 2 individuals who have had extensive experience in terms of both the Youth Justice Agency and Probation Board in relation to the provision of restorative justice services. So I suppose for us that is the check mechanism in terms of that initial accreditation process, and ensuring that we as a department have assurances in terms of the quality of the work that has been delivered by those organisations and practitioners, and that will be delivered in terms of the new process.
Okay, thank you, Chair.
Thank you very much. Thank you very much. Oh, Ciara's come in. Ciara, hands up, just in the nick of time.
Yeah, just 2 wee questions. Could you take us through how cases are currently allocated? Where they're received, who currently screens them, and how they're currently allocated out to organisations. And then secondly, a key one for me, how will you ensure that obviously the expansion of restorative justice practice to statutory bodies will not diminish the role and benefits of community-based restorative justice practices?
Carol, maybe if you don't mind, I'll deal with that, the second question first. So I suppose in terms of the allocation of the cases, the focus of this new process, the accreditation framework, is building on what we currently have trying to make sure that that's as robust as possible and that there are adequate safeguards in terms of the delivery of those services. The focus of the new accreditation framework very much remains on delivery of services by our voluntary and community sector partners. So as we indicated, Northern Ireland Alternatives and Community Restorative Justice are the two current accredited organisations. As I alluded to, we have 5 organisations that have applied for organisational accreditation. We have in and around 20 practitioner applications in at the moment. Those are all coming in from voluntary and community sector partners. So it's not that we are taking cases away from statutory partners. This is very much about expanding and growing the use of restorative justice and doing that in conjunction with our voluntary and community sector partners, if that provides any reassurance in terms of that process. And then in terms of the screening and allocation of cases currently, so as I've alluded to, the 2 organisations that are currently accredited and that deal with cases are Northern Ireland Alternatives and Community Restorative Justice Ireland. So in terms of the cases that they would deal with, the funding that is provided from the department is largely it's core funding that's provided and would contribute towards staff in those the staffing of individuals within that organisation. They have significant engagement with the police in terms of the identification of cases that they would then look at, which won't necessarily meet the criminal justice threshold in terms of a charge or an offence being taken forward, but in which there are significant concerns in terms of the individuals that are involved in that and the need to try and bring about resolution and restoration for the individuals that are involved in taking that forward. So I suppose there isn't at present there isn't a kind of formal allocation function that the department is involved in. Rather, there is funding to both organisations, which then contributes to the staffing of that organisation and the provision of services, restorative justice services, more generally.
Okay. Just finally, Chair, if you allow me, just in relation to obviously the more serious work and serious cases and the level of accreditation, you'd mentioned level 2 and 3. Can you just maybe outline what's the expectation of scale of need in relation to current restorative justice practice at those levels? And is there any expectations of what numbers that you would like to see across the North? And I suppose finally, it's like that equity issue across the North. How can we ensure that all communities can benefit from restorative justice practice?
And in terms of, I suppose, the approach that's being adopted more generally, given that we have 2 organisations in, quite distinct parts of Northern Ireland and not necessarily kind of that wider provision across the board, we're very, very keen in terms of this process going forward and in terms of the use of restorative justice. A focus is very much to try and expand and grow the use of restorative justice going forward, just given, the significant benefits that we can see from that and in terms of kind of the benefits that for individuals that have been involved in incidents where harm has been caused, trying to bring the 2 parties together and to get resolution in relation to that. We're starting out, I suppose we have a phased approach in terms of how we're dealing with this. So we're starting out with diversionary disposals. The focus is very much in the first instance on cases that are on the cusp of the criminal justice process. So those that might otherwise be taken forward for prosecution. What we want to try and see is that there's an increase in the number of cases for which there's a restorative justice outcome. So that essentially there is a flipping, for want of a better phrase, taking cases out of the criminal justice system into an out-of-court disposals approach, where that is considered to be the most appropriate way of resolving the circumstances of that particular case. And while we're starting off with diversionary disposals with the view to them moving into the court stage at a later point, we're also taking a phased approach in relation to the geographical areas that we're going into. So we're starting off with 2 areas in the first instance. Around about 4 months later, we would hope to expand that into a further 2 areas. The basis of that has been largely to try and reflect, and I suppose before the applications had come in, we didn't know, where they were largely going to be from a geographical perspective. So the areas chosen had tried as far as possible to reflect some form of alignment with where we know that there's current service provision in relation to that. We're very, very keen, and obviously in terms of that kind of spread across the board and that equity of service provision, to expand particularly into areas west of the Ban as soon as possible after those first few areas have been undertaken. And what we would want to see is that there's expansion across the province, likely within kind of the first 12 to 18 months in terms of all regions or all police districts being covered in terms of those diversionary disposals, before we would then move into the court disposals. So as I say, I suppose it's an element of the unknown at this stage in terms of demand for service provision, as well as where service provision would be feasible. So that's kind of the rationale behind taking forward a diversionary approach, a phased approach in terms of diversionary then through into court cases, and also in terms of having that phasing in terms of the areas that would go into across Northern Ireland.
Okay, and can you confirm the 2 areas? I think one alternatives and CRJ Ireland were in, that there was 3 areas as part of a pilot, and they were predominantly obviously on around Belfast, etc. Can you confirm the 2 areas then that are in the first phase, and then?
I don't have a note of that with me, but I'll certainly send those through to the committee as soon as I possibly can. In police district terms, and I can't recall what this aligns with, it's police districts B and C and K and L. So B and C would be the first 2, and then that would be followed by K and L. They are, broadly speaking, kind of Greater Belfast area, and as I say, the rationale for that was to have co-joined police districts, so side-by-side police districts, to make that more practical in terms of kind of the training for officers and kind of movement of cases potentially across those geographical areas. But what we had also tried to do was to reflect, broadly speaking, and again why we went for kind of that Greater Belfast approach, where there was currently service provision, conscious that Belfast would have been one in which there would have been a considerable level of representation at the minute. Operationally, for our criminal justice partners, it was felt that it was better to go with some of those smaller individual districts in the first instance. Our sense is, and albeit we haven't kind of finalised the plan and what the rollout of the areas may be, but our sense is that the next area after those first sets of 2, so 4 in total, would be that we would likely go into kind of the northwest region, and then after that likely we would go into Belfast as well, and then looking at kind of the remaining police districts after that. And apologies, I should have had a note of those areas, but as I say, broadly speaking, it's police districts B and C and K and L that we're looking at.
No, thank you. And Chair, just one other, because I know it was raised when Alternatives NI and CRJ were in, just in relation to probation board and just the independence of, there was kind of, I don't know if you can correct me, that with regards to the likes of the out of court disposals and stuff, there will be a body that will actually decide, screen the cases and allocate them down the line, whilst probation board would also be a delivery mechanism as well. So could you clarify just that for us? Just that process?
Yeah, in terms of how that process will work. So I suppose the key aspect in relation to kind of the identification and the possible selection of cases for a restorative justice intervention will be by police and PPS in the first instance. So police would be identifying cases as possibly suitable for the use of restorative justice intervention. That would be considered by PPS in terms of whether or not that was considered to be an appropriate route to go down. And then I suppose we have the probation board as our independent referral body, and a range of factors come into play in terms of kind of their selection to provide that role. But I suppose as a statutory partner that has engagement both with perpetrators and with victims. So in terms of the work that they would do with individuals that are serving, they have community type orders, and also given the work that they have in terms of their victim information unit. So essentially, and the intention would be through the restorative hub, which in the first instance will probably have around 20 practitioners involved in that. As we expand in terms of the numbers of practitioners and we expand in the provision of services, we would expect to see that restorative hub, the numbers for that increasing, and there probably would be effectively a number of virtual hubs across the province in which practitioners would be housed, for want of a better phrase. And what we will want is, as far as possible, that there is equitable distribution of those cases to those practitioners that are involved in the hub. So depending on the numbers that we get in for the current application process, we would hope to have a significant proportion of those practitioners that are applying for accreditation being involved in that hub. And the cases would then, as I say, the primary function really in terms of determining whether or not there's to be a restorative intervention in relation to a case will be the decisions that are taken by police and PPS in conjunction, and then there would be the allocation out to those practitioners in terms of the allocation of those cases to those that are in the hub, and that obviously would be taken account of where practitioners were located, the expertise or types of cases that they may have experience in, the particular type of case that's being involved. But as I say, we would want as far as possible for that process to be equitable in terms of the allocation of those cases.
No, that's great. Thank you.
Okay, Patsy.
Yeah, Chair, just to get back to the community restorative justice, could you maybe explain to me, in regard to the delivery of it, that's one thing, and we heard that from their point of view, it seems to be very effective on the ground. Can you explain to me the mechanism of, there's delivery, I know the finance and all that, the mechanism of oversight from the department on community restorative justice projects, because you're obviously, if I picked up correctly there, you're thinking of expanding them outwards. Could you just explain that to me, please?
I suppose in terms of the new accreditation process going forward, there's obviously the checks and assurances that we will want to achieve through that accreditation process, the applications coming in, the consideration of those and the evidence provided, so that we're satisfied in terms of both the organisations and the practitioners that are going to be delivering that service going forward. As part of that process, when the organisations have been accredited and those practitioners are in place, there will be a governance arrangement in terms of reporting back to the department around the work that's being undertaken. We will have very regular engagement, and particularly through our protocol lead, with those practitioners that are involved in the restorative hub, so that there will be a close kind of engagement with our lead in terms of the individuals that are operating in that hub. We will also want to have regular progress reports in relation to KPIs and monitoring of the work that's being undertaken. We'll have regular engagement with those organisations as part of that process going forward, and in all likelihood we'll probably have quarterly meetings or else 6 monthly. I think more likely quarterly meetings in the first instance. Yes. With those organisations that have practitioners in the hub. As you say, we'll want to have regular engagement with the hub practitioners in and of themselves, and we will also require that there are progress reports submitted to the department in terms of the work that's being undertaken, and a key aspect of that we want to see is in terms of kind of the throughput of cases, the timeframes that are being adhered to, and what the views are of those that are being involved in that process. And as you say, at a most basic level, their satisfaction with the service that's being provided and the difference that they feel that it's making.
Just you used the phrase there, protocol lead. Could you expand a wee bit further on that for me, please? I just don't understand what that means.
No, and apologies, I should have explained that properly at the outset. So we originally had a restorative justice protocol in place in 2007. there was a review undertaken of that with a new protocol published in 2023, and I suppose it effectively sets out kind of the framework or the structure that applies in relation to the new accreditation framework and the practice standards. So the framework and practice standards document that we have brought forward has reflected what is in that protocol document. So in terms of the different levels of accreditation, what the expectations would be involved in relation to that, what the requirements would be in relation to the accreditation processes, the assurances that we will want to have in terms of service delivery going forward. So the protocol lead is really the name for our restorative justice expert practitioner who's working with the department to bring forward the new accreditation framework and the practice standards. And they will have, as I say, they have 20-25 years experience in this field, have been involved in both the youth and the adult world in relation to restorative justice, and have an extensive level experience in relation to this. So they will have a key role in terms of this work being taken forward and the monitoring and review of it and oversight of it as we take that process forward.
Chair, excuse me, that's appropriate. I think it might be helpful if we could get a copy of that documentation, please.
We're more than happy to share both the protocol and we'll resend as well the accreditation framework and the practice standards. That's not a problem at all.
Okay.
That's grand. Thank you very much.
Thank you.
Okay, Veronica and Jenny, that's it. Thank you very much for your time. It's been really appreciative and it's been very informative, so thank you. Thank you very much. Okay, folks, we'll move on then. Agenda item number 5, correspondence. Can I inform members that there is a correspondence memo and 16 items of correspondence at pages 136 to 295 of the meeting pack and 1 item at page 7 of the table pack. And I advise members that I will draw their attention to 7 of the items, and then members will have an opportunity to comment on any of the other correspondence as they see a particular interest. Can I refer members to page 139 of the meeting pack, which contains correspondence from the Minister of Justice to the Secretary of State regarding the renewal of the direction under section 1A7 of the Prison Act Northern Ireland 1953, which was forwarded to the committee by mistake. Can I inform members that the Department has asked to recall the correspondence? However, under Standing Order 468, no correspondence can be withdrawn without knowledge and approval of the committee. So can I ask members if they're content that the correspondence is withdrawn? Yep. Okay, refer members then to page 142 of the meeting pack for 5.3, which contains a response from the Department of Justice to questions the committee had asked in relation to whether changes to the processes and implementation of the Troubles Permanent Disablement Payment Scheme to address unintended consequences can be made locally by the Department of Justice, or if they can only be made via legislation at Westminster. Can I inform members that the Department has advised that it is only responsible for implementing the payment scheme in line with the underpinning regulations, and that the policy responsibility for the scheme rests with the Executive Office. It would therefore be a matter for TEO to advise on if and how any changes to regulations might be made. So I seek members' agreement to forward the committee's questions to the Executive Office for response. Great. Refer members then, 5.8, refer members to page 214 to 215 of the meeting pack, which is correspondence from the Committee of Finance, copying an update from the Department of Finance on the review of arm's length bodies to all statutory committees. The committee has also been copied into further correspondence on this matter from the Chair of the Finance Committee to the Minister of Justice. This can be found at page 7 of the table pack. Can I seek members' agreement to request that the Department provides the committee with a copy of the response to the Finance Committee? Agreed. 5.10 then, refer members to pages 239 to 243 of the meeting pack, which contains a response from the PPS, the Public Prosecution Service, to questions the committee had asked on why so many cases related to non-fatal strangulation are being referred to the Magistrates Court rather than the Crown Court, and whether there is any potential that the seriousness of such cases are being downgraded for the purpose of speeding up justice. Can I inform members that the PPS response explains why previous cases of non-fatal strangulation might be referred to the Magistrate Court. However, it also highlights that a recent ruling in the Court of Appeal has resulted in a significant recalibration of decision making in relation to the appropriate court venue for such cases. The PPS internal guidance has been amended to make clear that the most appropriate venue for cases of non-fatal strangulation is the Crown Court, and the PPS has provided figures to suggest that more recent cases reflect that position. The correspondence also refers to delays in the justice system and advises that the PPS Director is willing to attend a future committee meeting to discuss these matters with members. Can I remind members that the committee has agreed to request that the Lady Chief Justice, the PSNI and the PPS attend a future committee meeting to discuss delays, and that the clerk is liaising with these officers to determine a suitable date for these sessions. Can I ask members if they're content to note the response, or if any other information or clarification is required? Doug?
Yeah, Chair, I mean, I've raised this a lot, both on the floor of the chamber and in here. I think it's concerning that when non-fatal strangulation came in, there was no sentencing guidelines in place. And we need to ask the question, why was there no sentencing guidelines put in place? And secondly is, they've changed this rule based on a court ruling in February 2025, but didn't make the changes till July 2025. Does that mean that cases between February and July of non-fatal strangulation were heard in the wrong court? And therefore, is there any recourse for those individuals to ask for their cases to be reheard again in a Crown Court, if that's the case? Does that make sense?
Yeah, I hear you. Yeah, we can write back to them.
Yeah, I mean, I'm concerned, and it's one of the arguments I've had about sentencing guidelines. The fact is that we didn't have sentencing guidelines, I think, is really concerning.
Okay, members content? We write back and clarify. Any, Emma?
Yeah, no, I'm content enough with that. I think there's probably is there scope there within the sentencing bill?
Oh, there's plenty of scope in the sentencing bill.
Open another can of worms. But could I just go, you see, just in terms of 5.9, just around the CLG stuff around the SL1?
Can I ask you just to hold off till I get through the stuff, and then we'll come back to you? Is that okay?
Okay, yeah.
That okay? Is this within correspondence you're bringing up? I'll come back to you if that's okay. Can I refer members then, just in case I raise it, refer members to page 268, that's item 5.13, which contains correspondence from a victim requesting that the committee give consideration to issues raised as a result of a Department of Justice failing to register 3 members of the Cowdery family on the Prisoner Release Victim Information Scheme Purvis, despite the application being made in 2018. Most of us will be aware of this case. The individual has also provided copies of correspondence sent to the Justice Minister in connection with the meeting with the Minister on 20th of November this year. Can I remind members that following the oral evidence session with the Permanent Secretary, the committee had asked for further information on the commencement pre-release testing in advance of the completion of the minimum tariff. Can I seek members' views on how they wish to respond to the individual on this matter? Doug?
Again, I've engaged a lot with this individual, Chair, in regards to this. And the nub of this I think there's 2 points to this. One is I still believe that the Victims Information Scheme should be opt-out, not opt-in. And I would say it's something we need to understand why it is not. The argument that was given when I asked the Permanent Secretary was they didn't want to bombard people who've just become victims, but I think it's the other way around. I think they've got it wrong. But in this case here, I think what Charles Little is saying is if the court gives a sentence which is the retribution, the deterrence part of the sentence, let's use the term 10 years, then that individual should serve the 10 years before he's allowed out. But what we've actually got here is the prison service allowing them out at the 7-year point. So 3 years before that minimum court tariff has been served. And I don't know where the legal basis is for the Northern Ireland Prison Service to do that is. Mm-hmm. And I wouldn't mind trying to find where that legal basis is.
Yeah. So can I propose that we forward this correspondence from Mr. Charles Little on to the Justice Minister of the Department and ask that question? He alludes to that in his points, but then also ask for that legal basis.
That would be useful, but what I would say, it might be pointless forwarding this because he's already forwarded that to the Justice Minister and met the Justice Minister and discussed this. Mm-hmm. Whether or not he's come to us now because he wants us to look into it because he hasn't got what he wanted from the Justice, I don't know. But
one of the points is specific to his family,
yes.
But the other 2 points are systematic.
They absolutely are.
Chair, just to remind members that following the session with the Permanent Secretary, the committee did write afterwards, and the response actually hasn't come back yet, but specifically requested clarification of the regulations and processes governing pre-release testing of prisoners, including how far in advance of the completion of the minimum tariff that pre-release testing can begin, and who is responsible for decision making in this regard.
So we'll just try and chase that up, I think.
And it's not just this case, Chair,
No, of
as well,
course,
because
yeah.
we had the James Meehan case
Yes.
as well, which I think
Absolutely.
is important.
So, Chair, is there anything in the meantime that you want to go back to Mr.
Well,
Little on?
Other than to say we've been acknowledged his letters, correspondence, and that we are trying to gain answers. Would that be fair? To his questions, is that okay? 5.14, refer members to page 284 to 288 of the meeting pack, which contains further correspondence from the individual in relation to access for students to the Bar of Northern Ireland. Can I remind members that the committee has commissioned research on access to the Bar for students by the Assembly's Research and Information Service, which, given competing work pressures, is expected to be available around Easter time. So can I seek members' agreement to therefore note the correspondence at this time and consider further when the raised paper is available? Agreed. Can I then go to 5.15, refer members to page 289 to 290 of the meeting pack, which contains correspondence from an individual regarding requesting that the committee give consideration to issues in the handling of legal complaints in Northern Ireland. Inform members that the individual highlights their own experience of making a complaint with the Law Society and asks that the committee consider the current complaints handling procedures in relation to solicitors in Northern Ireland is sufficiently robust. So can I seek members' views on how they wish to respond to the individual matter? I'm of the mind, members looking at this, that we might write to the Department of Justice, the Department of Finance, which is the sponsoring department of the Office of Legal Services Oversight Commissioner, and then also write to the Legal Services Oversight Commissioner herself, and just see if they can respond to the points made. And of course the Law Society. Are members content that we put it around all the houses and see what comes back? And then 5.17, refer members to the invitation from the Northern Ireland Human Rights Commission on pages 294 to 295 of the meeting pack, and advise that they should RSV directly if you wish to attend. So can I then bring in Emma on your point, Emma?
It was just on the correspondence point 9 around those SL1s, just to suggest that they be sent to Human Rights Commission and Equality Commission, and feedback sought from the proposed, the template that was the RHA stuff.
This is a letter to the chairperson's liaison group. Is that the one? With regards to how we deal with SL1 stat rules. Is that the one?
Yeah.
Just with the human rights. Chair, I think departments automatically have always copied them to the Human Rights Commission, but I suspect since the Windsor framework, they're probably the Equality Commission too.
I would just check on that's happening.
Oh yeah. I know, I hear what you mean now. But this is basically just a letter from the chairperson's liaison group to all committees. Yeah. Okay, members content to move on then. Agenda item number 6 is forward work programme. 6.1, Lady Chief Justice response regarding delays in the criminal justice system and taxation. Can I remind members that the committee had agreed to write to the Lady Chief Justice requesting that she attend a future committee meeting to provide oral evidence on delays in the justice system and taxation, along with the PSNI and the PPS, the Public Prosecution Service. Can I inform members that the Lady Chief Justice has responded to the committee's request, stating that she would be very happy to assist the committee in their work on these matters, and as noted earlier, the Director of the PPS has also expressed his willingness to attend the committee on these matters. Can I ask the Clerk to talk on this?
Chair, yes, thank you. It's just to mention to members that obviously it would make sense really to hear from the Lady Chief Justice on the two issues on the same day. The difficulty with that though is that taxation is probably a little bit more immediate actually, because it forms part of the bill. And I know I've checked with the PSNI, and I think the first date that they can come back again to talk about the delays is probably mid-February, early to mid-February, which would probably be too late in terms of the bill deliberations. And I know that the committee had proposed to hear from them both, from the three organisations on the delays on the same date. But I think given the circumstances, that might not actually be possible in terms of the LCJ, certainly. It might be need to separate them out and have the PSNI and the PPS at a later date on those issues. The other thing, I'm working obviously with the
the LCJ's office to arrange the external meeting in the Royal Courts of Justice. So there could the session with the Lady Chief Justice could take place at that visit in terms of a formal meeting. But again, it would depend very much on her availability. I'm trying to check whether the LCJ might be available for the 22nd and 29th of January. The other thing that might be necessary, if she's not, is to possibly think about an additional meeting one of those weeks in order to get it. I think it's important to get it done for the bill.
Yeah.
In order to inform the deliberations. So it was just to make members aware that that is the position. And the other thing is, if it's an external meeting, there won't be cameras necessarily. There will be an audio recording as normal, and that will be put up after the meeting.
Okay, members content with that? I know we try to get it all together, but it's just not going to be possible with regards to pressures of the scrutinising of the bill. And tech session in itself is a big issue. And then, of course, speeding up justice is the other aspect too. Are members content?
Yeah.
Okay. 6.2 then, forward work programme. Can I inform members that the latest draft of the committee's forward work programme can be found at pages 300 to 306 of the meeting pack? Can I seek members' agreement to the forward work programme? Agreed?
Agreed.
Agenda item number 7, chairperson's business. Can I advise members I have no chairperson's business this week? Agenda item number 8, any other business?
I've got one, if I can.
Doug, come on ahead.
Chair, if I can, I think this is going to come down to us whether we like it or not, and that's the issue of non-disclosure agreements. I think the investigation into the Presbyterian Church of Ireland may kick up some issues in regards to that. There's two issues which I don't know about, and I'm worried in case I missed them coming through Justice, and I would apologise that's the case. But the Courts and Tribunal Service no longer register or put on the public register findings of employment tribunals if there's an NDA been signed. And the ruling that the judge gives simply says the claim is dismissed following withdrawal. And I don't think that's fair on the claimant and indeed the respondent. And I wouldn't mind, if possible, trying to get some information back in regards to that, or somebody, and I don't want to add to our workload, but somebody to just come and tell us why they do it in such a manner.
Okay. I know you'd raised this in member statements this week.
I did, yeah. And I can, Chair, so you're aware, I raised it because I've had an increase of people coming and saying, I have an NDA and I have problem getting future employment because my future employer want to know why I left my last employment, and I can't tell them because of an NDA, and I can't send them to the register to say, look, because it's no longer on the register.
Yeah. Okay, that's a fair point. So there's blind spots there.
I think so.
Okay.
Sorry, Chair.
Go ahead.
Chair.
Potential.
Hold on, Patsy.
A potential oral briefing then, if preferable.
Look, I don't want to add to the workload. We've got a big workload here. I don't want to add to it. If there's any other way of doing it, that's fine. But
well, we've got that flexibility then. The clerk has the flexibility to see what we can pass.
I mean, it's up to you.
A written response maybe in the first instance, and then
possibly a written response. I mean, look, I don't want it to just be my issue. If other people have concerns, that's fine. If it's just me, then I'm happy to meet them myself.
Yeah, no, it's a big enough issue that we should look at. Patsy?
Chair, thank you very much, and I support Doug in that. I sat through, must be about 12 years ago, a public accounts hearing into NI Water, and that was one of the issues that was raised, the use, or should I say abuse, of NDAs. I do think that, I'm not sure whether this is the correct committee or not, I just don't know, but I think there is a wider body of work into public bodies or departments if they use NDAs and the circumstances under which they do use NDAs. It would be very concerning to me that there are things like this happening out there that may involve public monies, and indeed, as a consequence of that, do affect people's employment ability because they obviously can't be released, and that they may be in circumstances being abused. So I'm not quite sure how we take this, where we take it, whether we revert back to the findings of the PAC way back then. It was dealing specifically with NI Water and NDAs, but as far as I can recall, there was a direction from a government department at that stage about the use of NDAs in public bodies, that is.
Okay, well, we can maybe do a wee bit of digging, but in the first instance, I think we write to the department just to...
Yep. That'd be grand.
And it also sits, Chair, sorry, it also sits with the Department for the Economy. who hold the legislation for that as well.
Yeah.
But because it's a courts and tribunal service and the judges give the ruling,
Yeah.
we clearly have to.
Yeah. Okay, I'm happy enough to proceed with that. Any other
Yep.
matters?
Thanks, Paul.
Any other business? Okay then, agenda item number 9 is date and time and place of the next meeting. Can I advise members that the next meeting will take place on Thursday 11th of December 2025 at 2 p.m. in room 30 Parliament Buildings. I adjourn the meeting. Thank you, members.
You got away with it, Emma. You got away with it.
I was really